DUI arrests in Hawaii are being called into question tonight. Good evening, I'm Yenji Denise.
And I'm Kenny Choi in for Paula Akana. Just as police are launching new DUI crackdowns, one legal challenge could be a game changer. KITV4's Andrew Purr has all the details. Andrew.
Yeah, Kenny and Yenji, at issue is whether police officers have to read DUI suspects their rights before they give breathalyzers or blood alcohol tests.
If you get pulled over for drunken driving, you have a choice. Agree to a breathalyzer or blood draw or spend up to 30 days in jail. Local attorney Jonathan Burge believes that's unconstitutional since police don't provide a Miranda warning.
Think of it like the Gestapo, you know, the old days when you get the light on people and you will talk. Well, that's what they were doing before Miranda. And the U.S. Supreme Court says we can't do that to our citizens. We have to have knowing and voluntary conversations.
Last year, Burge took his arguments before the Hawaii Supreme Court on behalf of his client Yang-Shik Wan, who was arrested for DUI in 2011. Since Wan was never advised of his rights, Burge says the breathalyzer his client took should not be used as evidence. Burge also takes issue with what happens when DUI suspects are taken in for booking.
When they're at the station, they're told they have a right to refuse, they're asked if they want to refuse, and when they do refuse, they're arrested right there on the spot.
Other attorneys who specialize in DUI cases agree a Miranda warning is needed if the state is going to criminalize refusal to take a breathalyzer or submit to a blood test.
What we're talking about here are warrantless searches of a person's breath and warrantless searches of a person's blood.
Burge claims police not only failed to Mirandize his client, but they also refused him an attorney. It's right there on the implied consent form, which Mr. Wan refused to initial. During oral arguments before the High Court, Deputy Prosecutor Brian Vincent said Hawaii drivers give up their Fourth Amendment rights as soon as they get behind the wheel.
Unfortunately, we don't have enough policemen in the state to conduct a blood alcohol test on everybody before they get into their cars. So we have allowed for a very targeted, very specific, and we think very reasonable search post entering the car.
Burge, however, scoffs at that argument.
You're giving up a constitutional right and not even knowing it? I don't think there's ever been that before.
It's unknown how many DUI cases could be threatened if Hawaii's High Court agrees with Mr. Wan and his attorney. The prosecutor's office had no comment today, except to say it won't speculate on the outcome of the Supreme Court ruling. That ruling expected soon. Kenny, back to you.